Good evening. Welcome to another episode of Aging with Attitude. My name is Phil Koch. I'll be your host this evening. Tonight we have a friend of mine who's come on to talk about some advanced directives, and his name is T.R. Sanford. T.R., welcome.
Thank you. Pleasure being here.
Yeah. So tell me more about your background, and you're an attorney, and tell me more about the type of attorney you are.
Well, like I said, I'm what we call an elder law and estate planning attorney. Okay. Estate planning, of course, is dealing with transfer of wealth from one generation to the next. Elder law is very much along the same lines, but it's a little bit further down the road, and oftentimes it's where rather than worrying about transferring wealth to folks, it's, oh, I don't have enough wealth to last my lifetime, what do I do now? And it's really the planning, the intermediate planning between, the time someone retires and the time someone passes away.
Right.
And lots of different little objectives there.
So you're dealing with not just people that are planning their own estates and where that's going to head, but probably siblings.
Absolutely.
And family members, so you're involved with the whole family gamut. No?
That's exactly right.
Yeah.
That's exactly right. It can be very, very interesting at times.
Well, tonight we're here to talk and meet TR, but also to talk about advanced directives. So why don't you give us an informal definition of advanced directives and what that means to our viewers?
Sure. Most of the time when folks bring up the term advanced directives, they're really thinking of it in a medical context. Here in North Carolina, we're talking about documents such as a living will, a do not resuscitate, and also a form called a MOST form, a medical order for scope of treatment. But even, I prefer a more broader definition as any document in which we are trying to relay our wishes at a time when we cannot communicate those wishes to folks, during incapacity and disability. But under that definition, in addition to the living will, do not resuscitate, and MOST form, we also want to throw in the healthcare power of attorney and the financial power of attorney to make sure that everything's covered.
Okay, so a lot of our viewers that are watching tonight are most familiar with a will.
Right.
That's one form of part of the advanced directives. So let's take one at a time and talk about other things that you would suggest if they don't already have other than a basic will. For example, power of attorney.
Sure, and I always tell folks that two of the most important documents that you can ever have are the healthcare power of attorney and the financial power of attorney. Right. For one simple reason: one, they're very inexpensive, and it gives you the opportunity to make your wishes known and to appoint those people you want to execute those wishes for you. The alternative is if you don't appoint someone to make those decisions for you, your children or your spouse or someone may end up having to go to court and be appointed guardian, which could be time-consuming and costly depending on how things pan out. But the financial power of attorney and the healthcare power of attorney, there's a lot of confusion as to what they each cover. Yeah. The healthcare power of attorney, by its name, obviously, takes care, you appoint someone to manage decisions over your person, talking to your doctor, making healthcare medical decisions only at a time that you can't. Right. And that's one thing that a lot of folks don't understand is that a healthcare power of attorney could be a document we call a springing document, meaning that it's only effective when you can't talk to the doctor or when you're unavailable, i.e. unconscious, incapacitated, incompetent. Mm-hmm. So as long as the doctor can talk to you, no matter what the healthcare power of attorney is saying, they're going to follow your instructions. I guess going a step further, you can also, well, I'll leave it at that moment right. There.
So, but we have because I own a senior care company, mm-hmm. and we get these questions a lot. People will say, by the way, have you prepared advanced directives? And a lot of people say, well, I'm not sure what you mean by that. So we'll start to go into it. We'll say, well, a will, a basic will, which mm-hmm. most people will have. And is it safe to say that if they're coming in from out of state recently, they should have even their wills looked at, even if it's been prepared in advance?
Absolutely. There is a common misconception out there, and that's if you are from out of state that you have to get your documents redone in North Carolina. That's not always true. Okay. A lot of times, the law allows for documents from out of state as long as they're executed under the properly under the laws of the state in which they were created and meet certain requirements here in North Carolina, they're perfectly valid here. But I always recommend, people have them looked at by someone just to make sure they conform with all the rules, because there'd be nothing worse than to have, think that your documents are okay, and then when it comes time to use them, they're not valid. So yeah, absolutely have somebody take a look at them, but they're not always necessarily, they don't always necessarily need to be redone. Somebody being
an attorney, or in particular an elder care attorney. Can you describe the difference between an elder care attorney and an attorney, or if there's a difference?
Sure. I guess the difference, I mean, we always talk about, if you want to go to a doctor and you have a foot problem, you don't go to a heart surgeon. You always want to go to the folks that deal specifically with the subject matter at hand. Right. Today's world has become so specialized and folks concentrate in different areas. You really want to talk to someone who deals with these different issues on a day-to-day basis, and that's all they deal with. An elder law attorney is going to be the guy who deals with the folks who are trying to meet long-term care costs and trying to make sure that their documents are all in order. So they're going to be familiar with all the ins and outs and the bumps in the road that come up. Often, it's right. Interesting. You look at documents that are drafted by someone who doesn't necessarily deal with elder law, that, like a power of attorney, but it may not have the kinds of authority, the broad gifting language, and the broad decision-making authority that an elder law attorney might put in there, because we know that those are the kinds of things that people need.
Right. So, okay. So, have your documents looked at by an elder care attorney in your local region, if at all possible. Mm-hmm. They're going to be looking at your will, power of attorney, mm-hmm. and talk about what power of attorney, if you appoint somebody as power of attorney on your behalf, who would you recommend that person being, and what do they have the legal ability to do on your behalf?
Well, that's a great question. Now, in terms of appointing folks, mm-hmm. very often we're going to appoint the spouses first, because that makes the most sense. So the people that are closest to the situation probably know the other person's wishes much better than anybody else, even the children. After that, we might look at children first, as long as they are suited for the job at hand, i.e. Somebody who's savvy financially might be the guy or the girl that you would like in charge of the finances. If you have a child or someone who's in the healthcare profession, maybe appoint them as right. the healthcare power of attorney. And oftentimes it's the same folks, no matter what, just because those are the choices that are available. Sometimes, and it's possible that you can have a third party, i.e. an attorney or a family friend. We've even had pastors act in certain capacities. So it's just any trusted third party. In terms of, I think I forgot the second part of that question that you were asking.
Well, I mean, I think you answered it. It was who you should ask, mm-hmm. and what legal rights does that power of attorney, what can they do?
Yeah, you can draft a power of attorney, whether it's a healthcare or a financial power of attorney, as narrow or as broad as you would like. Okay. Oftentimes, for instance, if you go and purchase a house, in that giant stack of paper that you are signing off in over that 45 minutes that you're in your house closing, is probably going to be a limited power of attorney to correct deed mistakes. Right. You could do it. You could draft your power of attorney for something as narrow as defined as that, a specific event that's only good for that, or it could be effective immediately for everything under the sun, essentially. Oh. Really, the only thing you really can't do in terms of a financial power of attorney would be have them create a new will for you. You couldn't have them do that, but it's pretty much anything under the sun that has to deal with your money, you could have them do. The other thing you can have, and this is one of the areas of confusion that I also find, is it going to be effective now, the moment you sign it, or is it going to be effective later, only when you become incapacitated? If it's effective now, that's often how we do it, because you never know when it's going to be needed. The other part where if it's effective only after someone is incapacitated or unavailable, that's what we call a springing power of attorney. Okay. It springs into effectiveness upon a triggering event, i.e. incapacity. The other thing that we want to make sure that we have in the document is making it, particularly in a senior situation, is making it a durable power of attorney and not just a general power of attorney. Powers of attorney, if you draft one today, if it's not a durable power of attorney, the moment you become incapacitated, it's no longer valid, what purpose would it have served ever. So we want to make sure it's got the language to make it durable, and essentially it's got to say something to the effect of, this power of attorney shall not be affected by my subsequent incapacity or disability. Just words to that effect. That makes it a durable, which makes it valid from the time either it's effective, either on signing or the triggering event, to the time of death. And that's another area of confusion, is most folks don't understand that once someone dies, that power of attorney, whether it's healthcare or financial, is no longer valid. So they can no longer make decisions for folks. And sometimes there can be a window where there's no one appointed to make a decision for you.
Okay, so durable power of attorney is even if they are incapacitated. If it's not durable, then it's a basic power of attorney, and that basic power of attorney enables them, and I'm not putting words in your mouth, but that enables the individual to do legal and financial things on behalf of that individual?
No, general power of attorney, if it's a durable power of attorney, let's take a step back. General financial power of attorney lasts from the triggering moment, whether it's signed, to incapacity.
Okay.
Now, if it's a durable power of attorney, it will continue from incapacity to death.
Oh, gotcha. Okay.
So you want to make sure you've got that language so that you're covered for the whole lifetime, timeline, so to speak. And then, and I guess on the other side of that, you've got the medical power of attorney, which is valid up until the time someone passes away.
But if you have power of attorney, whether it's durable or regular, can that individual, if they're a power of attorney, sign things legally on behalf of that individual?
As long as it's valid at the time that they're trying to use it, absolutely, they can sign. It's a lot of times you will see if they're very broad-based in language and the powers that they grant, it will give them the authority, to do just about anything. So they could go to the bank,
checks and
write
take
checks,
money out and,
pay bills, enter into contracts, sell real estate, purchase insurance policies, things, transfer ownership, sometimes change beneficiaries.
If I may point out to our viewers tonight, because again, having been in the senior care industry, I've seen this happen. Third-party individuals sometimes get power of attorney, and sometimes they do things that we don't want our family members. Sometimes money is taken out of bank accounts. You got to be very careful as a sibling, as a spouse. If a third party that you're not as aware of somehow gets access as power of attorney, we knew of an individual at a building that we were caring for another individual, but that individual had a neighbor, and there was a third party caregiver that got access as power of attorney. The children didn't know about it until it was well into thousands and thousands of dollars subtracted from the bank account. The siblings found out about it, and it was a very scary thing. So it's a very powerful thing, a power of attorney.
Yeah, absolutely. And the situation you just described is something we're seeing more and more, every day, just because of the situations. We're finding people living longer and relying on parties that aren't traditionally the folks that we would deal with. And every power of attorney has what we call a fiduciary duty to do what's in the best interest of the principal, the person who created the power of attorney, mom or dad in most situations. So if they take the money out for their own care, they've broken the law. Yeah. And they've breached their fiduciary duty, so they can get in trouble for that. But it's very difficult. It's an evidentiary question, and it's very difficult to really pursue those things, although it's not impossible, of course.
Okay, so power of attorney can do legal and financial things on behalf of the individual that they assign them to be power of attorney for. Now, healthcare power of attorney. What is the difference between what we just talked about and what a healthcare power of attorney can do?
Yeah, up to this point, we've really been focusing more on the financial aspect of it. Healthcare power of attorney, same sort of idea. You're appointing someone to make decisions for you, but rather than a financial, we're talking about over your healthcare decisions, over your person, so to speak, talking to the doctor. And like I mentioned earlier, it's a springing document, so it's only when you can't talk to the doctor. So you roll into the emergency room and you're unconscious. Then your healthcare power of attorney can take over if it's not an emergency situation, because they're always going to stabilize you, of course. And if you you're in a coma, or if you're incompetent, which is probably more common, that we see people with Alzheimer's or dementia, children coming in and making those decisions for them. And it really covers the whole gamut of healthcare things, right down from where you live up to the kinds of treatment that you will receive. And it can be, you can also Healthcare powers of attorney very broad or very narrow. I would prefer to have something broad because you want to make sure all the bases are covered, because in absence of the power to do something, again, you're going to have to go to court, and court supervision is good, but it's sometimes time consuming and of course costly.
So let's take up a fictitious situation. Let's say an individual went into the hospital, a woman was put on life support. The husband comes in and thinks, based on prior conversations, she should come off of life support. Can the spouse, without being appointed as written healthcare power of attorney, can that individual actually ask the hospital to have the spouse being taken off of life support?
Depends on, well, a couple of things at play here. One, they're in the hospital, and unless the healthcare power of attorney in and of itself has what we call HIPAA medical release language in it, they're not going to have access to what's going on in the first place in the hospital.
Okay.
So, most healthcare power of attorney are going to have that. In addition, the healthcare power of attorney would have to grant them that authority. Sometimes you will see a combined form with the healthcare power of attorney plus the living will, which traditionally covers life support situations. But oftentimes that's going to be dealt with in a separate document. You can see most of the time with you'll look toward the healthcare, the living will for those kinds of instructions, and the doctors are going to go to next of kin and the healthcare agent in the absence of that.
Right. And that's good, you brought up living will, because I get a lot of confusion on that from people, the difference between healthcare power of attorney, which is assigning something to somebody, versus a living will. Can you describe the two?
Sure. The living will by itself is a document that says, if I'm in these situations, life-ending situations where I'm either have a terminal illness, and of course you're on life support in most of these situations. Terminal illness, which is going to result in my death. I'm in a coma and my doctor thinks I'm not going to come out of it. Or I've got such advanced cognitive dysfunction that my brain's not really operating everything and I'm on life support and required. If you can basically leave instructions to the doctor in a living will in that situation to say, hey, I don't want life-prolonging measures. Take me off, let me die naturally. And in North Carolina, the form is actually called an advance directive for a natural death. And that's really what it's talking about. Now, even if you've said that you don't want to be on life support, you can still make exceptions. And that's usually access to artificial hydration and artificial nutrition. And after the Terry Schiavo case back in 2007, 2008, there's a statutory form that's in the North Carolina General Statutes that talks about this. There is, and in that form, after the Terry Schiavo case, they made some changes, and it allowed the person who created the form to grant the authority to their healthcare power of attorney to override the document. And it's a very interesting sort of concept, because one of the unintended consequences of the living will is it sort of removes the guilt from the people who have to make that decision. And I've seen folks who are medical professionals who have gone through that situation, and no matter how they intellectually deal with it, they still feel like they killed their parents, because of they had to make that decision. The document allows them, to take that decision out of their hands, but allowing them to override it sort of gives it back to them. So it's a very interesting. It's interesting to watch unfold. But
so the living will is a written document that myself as an individual can write prior, God forbid, something happening, so that I declare to the courts and to the hospital, to whoever's taking care of me, what I would like under duress, under a situation where I cannot make those decisions myself. If I didn't have the living will, but I had a healthcare power of attorney, that person could make those decisions on my behalf in lieu of a living will. Is that right or no?
Yeah, if they're granted that authority in there, and they could. In the absence of that, you could end up, depending on the family dynamics and who says what at that time, you could end up having a Terry Schiavo case, and, very similar to that. But in addition to the living will, you've really got a couple other documents that need to be addressed in North Carolina, and that's the do not resuscitate form, and then the other form called a MOST form, medical order for scope of treatment. And those three forms together really sort of cover your end-of-life decisions. The do not resuscitate form, very simple, is they find you cardiac arrest, some sort of pulmonary condition, and you're not breathing anymore. do you want them to resuscitate you?
Right.
This is normally done on a yellow, canary yellow form that is issued by a doctor, and so is the most form for that matter. And then the most form is, and that's a very, the do not resuscitate is very narrow, very, I guess it really only yeah, it's very narrow, but then the most form is a little bit more broad and deals with a lot more things. Not only do we want to be resuscitated or not resuscitated, but you can also leave instructions for, treatment. What kind of drugs that you want to receive and things like that.
Really?
The most form is on a pink fuchsia type form, and it's issued by a doctor as well, or potentially a nurse practitioner. And they sort of travel around with you. They're what we call portable documents. And they are, most forms generally issued for folks with a chronic illness that we're expecting them to pass away in a relatively short period of time. And they're very, very good to have because it sort of streamlines, events and how they unfold.
So all these documents are forms that you can reach out to your attorney, or even better yet, an elder care attorney.
Right.
Or, God forbid, if you're under hospice care, they would be aware of these type of documents and you're coherent enough to be able to do it. Or if you feel that one of your own family members or church members might need these type of documents. I tell you, if I may say, from my own experience, having dealt a lot with senior care, is how often people assume, well, my daughter is power of attorney, okay? So she's got it all taken care of.
Yeah.
Well, that's not the case,
That's
right?
right.
Yeah.
That's absolutely right. And a lot of times, and just want to make sure one thing's perfectly clear, these documents, yes, can be obtained by talking to an elder law attorney or someone attorney, with the exception of the do not resuscitate and the most form.
Oh, you're right.
Those have to be issued by a doctor. And that's, and everything else perfectly fine. But oftentimes, back to what you were just mentioning, they all say, oh, my daughter's my power of attorney, and we look at the documents and no, that's not the case. Maybe she was named the executor in the will,
right.
and that's it. And they may not even have powers of attorney. So that's one of the reasons why folks need to go and have their documents looked at. So particularly if they were done 10, 15 years ago, because as we get further away from that event, what we remember them saying and doing, those documents, changes. And often I find that people think their documents say one thing and they say something completely different.
Right.
So, or they just don't have them.
Or they'll say, well, my daughter's on the bank account.
Right.
So they think that also means she has power of attorney or healthcare power of attorney or both.
Right.
Which is not the case unless it's specifically written down and a lawyer signs off on it.
That's
correct?
right. They may have access to that account, but that's it, unless they have a power of attorney. And it's a very challenging situation when they get into that area and they're not covered.
Now, going back to the issue of power of attorney or healthcare power of attorney, can more than one individual be asked to be power of attorney? Because we had families, I know on the power of attorney side, that we're all siblings.
Yes.
Were power of attorney. Is that?
Yeah, absolutely.
Yeah.
You can basically structure your powers of attorney any way you want to. I like to have one person because it streamlines the chain of command, so to speak, and streamlines the decision-making process. But oftentimes people don't want it that way. You can have your spouse and then you can have your children acting together. Now, even if they're acting together, you can dictate how they act together in their decision-making. One way is you can have, John and Beth and Jay, your children, acting jointly. And then which means they all have to make the decision together. If one of them disagrees, no decision is made. That can slow the process down, which can be bad, and sometimes it can be good, depending on the family dynamics. The other way is you can have them jointly and severally, which means that they can all act or any one of them can act. And it just depends on what your dynamics are and what you want to accomplish and how you want things to go. And you can do
we
that.
see often, sadly, but end of life, nobody wants to think about. I mean, nobody wants to dwell on the possibility of them passing 5 years from now, 10 years from now, let alone in the immediate future. So oftentimes we've seen people not prepare anything because they feel that if they prepare that, they're going to jinx themselves.
Oh, yeah.
Or they're not ready for that, and not that they may never be ready for that, but eventually they are. It's better to be safe than sorry. And the sooner the better.
Yeah, and I tell you, that's exactly right, because let's look at the alternative if you don't do anything.
Right.
If you don't appoint someone to be your healthcare power of attorney or your financial power of attorney, someone's going to have to go to court and then be appointed to make those decisions for you if you get into a situation where you can't. Worst case scenario is that your kids don't get along and the court goes, I'm not appointing any one of you. We're going to make Department of Health and Human Services the healthcare person, the guardian of the person in that case, and then we're going to appoint an attorney as the guardian of the estate. So now you've got two people that are involved in your decision making or making decisions for you that you don't know.
Right.
And God bless all of them, but the attorneys and the people at Department of Health and Human Services, they've got a lot of things on their plate, so you may not be getting the kind of care that, or attention that you really want to have in that situation.
That's a very good topic, and that is, what happens if you don't assign somebody as power of attorney or healthcare power of attorney? Because if somebody becomes incapacitated or is not by court able to make their own decisions, then the court will appoint somebody.
Yep.
And that person may not be the person you probably will know making decisions on your behalf, which is probably, you know, in their eyes will be the best of their behalf. It doesn't always mean what the family wants.
Yeah, and I've worked with lots of the people that work on both sides, guardian of the person and the estate, and they all do the best job that they can, but oftentimes they have so many people that they're taking care of that they can't give you the kind of attention. And you know, and even if they were able to, you would prefer to have somebody that knows you make those decisions for you. So. Right.
What's the difference between an executor and an attorney, in fact?
Yeah, and I see this all the time. People, and we mentioned it earlier, people think, oh, my child's my power of attorney, but really what they mean is their executor. The executor is the person named in the will that's in charge of making sure your stuff goes to the people you want it to go to.
Okay.
And when we talked earlier, if you had a general power of attorney and you didn't have a durable one, and then actually once you pass away, the power of attorney is ineffective. So there's that window of time that no one's doing anything for you after you pass away, or making sure your stuff's taken care of until they become appointed by the court as your executor. So it's really, the executor is just the person appointed under your will to make sure that your stuff gets to who you want it to go to.
Okay, so to recap, advanced directives is a broad term that deals with many different things, including a will, a durable power of attorney or power of attorney, healthcare power of attorney, a living will, which is a document you can write on behalf of what you want going forward is your future wishes. And is there anything else that we missed?
Just the do not resuscitate and then the must form.
Do not resuscitate and the must form.
And that pretty much covers it.
And when in doubt, check with your attorney, your elder care attorney, and they'll know.
Yep.
Okay? Thank you very much, TR, for being on our show. Aging with Attitude, another great episode, and I'd like all of our viewers, appreciate your viewing in. We look forward for the next episode. Thank you very much.